This gathering, this gathering celebrates, of course, a wonderful book by a wonderful person, whom Howard will introduce in a minute, but it's part of a bigger project of the American Society of Comparative Law. The American Society of Comparative Law has started a book series, Studies in Comparative Law, published by Cambridge University Press, with a view to encouraging scholarship in comparative law. And this has been a wonderful initiative of the Society, which I think has in fact encouraged excellent young scholars to publish, and to publish in a way that will reach a great many people. So one of the things I wanted to say at the very beginning of this gathering was that those of you who are here who are either distinguished scholars who have many young scholars to whom you are giving advice, or are yourselves younger or even older scholars who have wonderful manuscripts that are in need of being published, bear in mind this, this book series, because I think it is the premier book series in comparative law, and we're very eager to encourage you. So that's a sort of preliminary remark, and then you're about to have an example of the wonderful scholarship that emerges through this series, and it's just been a great pleasure to get to know Ioanna Tourkochoriti through this and through the American Society. We're extremely lucky that we're doing this, at least in a virtual way, at Wisconsin, which has a very, very strong faculty, not only in law, in comparative law, but also in political science and a number of disciplines that are related closely to what we're doing, history and political science. And Harold Schwaber is one of the distinguished professors on that faculty who was willing to be the moderator for our group. So I'm extremely grateful to him for doing this. And now I relinquish the floor and all control to Professor Schwaber.
Hi, wow. Something I feel like I have to live up to something. That's the challenge. Thank you all for coming. It's delightful to see you. Ioanna Tourkochoriti, I hope I got that reasonably correctly, has a distinguished career. She was at Harvard for approximately 8 years, as I understand it. As a practitioner, she has appeared before the European Court of Human Rights, as well as has been a participant in human rights cases in Greece through the National Ombudsman's Office. She's currently located in Ireland. I hope all of this is correct. Ioanna, please correct me if I get something wrong here. And the reason, the reason for our gathering here today is that she has just finished a book, which I gather will be out in just a few weeks, on the meaning of freedom of expression in the United States and France. And rather than my trying to explain what the book is about, I think it'll be vastly more effective as well as efficient for me to turn the floor over to Ioanna and invite her to take 10 or 15 minutes to explain her thesis and whatever other comments she wants to make about the book before we open the floor to discussion. So Ioanna, please.
Excellent, thank you very much. I really couldn't be more delighted to be discussing with you today my project. So as I'm sure you know, in the US, the legal protection of freedom of expression trumps the protection of other values like privacy or human dignity. I don't think I need really to discuss the case studies that I engage with in the book with you. I may just go over them because they are helpful for me to explain the argument in the book a little better. So some examples of this difference relate, for instance, to hate speech, which is not protected in France. Defamation on the basis of a person's race is punished more heavily than ordinary defamation, and it constitutes a special crime. Hate speech is protected in the US. Further, another interesting case is the regulation of independent expenditures during political campaigns. So the United States Supreme Court has invalidated federal legislation imposing limits on independent expenditures, which usually come from corporations to support a candidate during political campaigns. And the justification there was that the legislation constitutes a violation of the speech rights that corporations may have. France regulates strictly the funding of political campaigns and imposes upper ceilings to campaign expenditures. This divergence is also obvious in the area of self-expression. Wearing conspicuous religious symbols is forbidden since 2005 in public schools and high schools in France. And in 2010, the French parliament banned the wearing of the burqa. Covering one's face in public places is forbidden in reference, in my opinion, to a conception of human dignity that dictates showing one's face to others. Further, the French Conseil d'État upheld the decision of the mayor, which was taken within his police authority, banning the practice of dwarf throwing. And other cases relate to conflicts between freedom of speech and privacy rights. So all those cases, the more I read to them, the more I realized that what I had to do was look into the interplay between law and liberty in these two legal systems. And I got this idea studying the American major Supreme Court decisions, which protect so strictly, which the Supreme Court took during the 1960s and protect so strictly in free speech. And in those decisions, there was a reference to the founding era and to the philosophy dominant during the founding era. So I thought that it would make sense for me to discuss the debates around the French Revolution, the Declaration of Independence in the US, and the construction of the federal government, which are so interesting because it is at this moment that the relevant debates as to the relationship between law and liberty took place. And I think that those debates can help us make sense of what is happening in the area of free speech. The American Supreme Court invalidates legislation which imposes limit upon speech. In France, on the contrary, the Conseil Constitutionnel operates in an entirely different way, and it didn't operate in the past as a court of appeals. This is something which, this is a function which is obtained relatively recently. It used to operate as an institution of interinstitutional control during the elaboration of legislation, and very frequently, legislation limiting speech did never reach the court. So I think that this has to do, as I said, with the interplay between law and liberty, and the debates taking place during the founding era are very interesting. And the methodology that I use for this analysis is largely inspired by Gadamer's. So I'm trying to trace signs of a different common character, a way of thinking, as Montesquieu calls it. I think that this way of thinking can help us make sense of what is happening in the area of free speech. It is an understanding of the role of the government that is reflected in the jury's opinions favoring the protection of free speech in the US and accepting limits in freedom. So the thinkers that were extremely interesting for me were Castoriadis and his conception of the imaginary institution of society, because I think that it is an understanding of this political imaginary which guides the jurists in a legal system concerning the necessity to protect free speech. Gadamer is also helpful here to the extent that he describes the process of understanding as being conditioned by some prejudice that we have. And by prejudice, he means preliminary judgment. He doesn't necessarily associate the concept with negative connotations. It's this idea that whenever we're trying to make sense of a legal text, we have our thought is preconditioned by a conception that we have as to how interpretation needs to go. But Gadamer is also extremely interesting because he provides very important insights in relation to revolutions. So revolutions lead to a dialectic between the old and the new. And he notes that even when life changes suddenly, as it is the case during revolutionary periods, there is conserved under the prima facie change of everything, a part of the past, which is much more considerable than we think, and which finds its authority by aligning itself with what is new. And I was also reading Arendt's analysis of the two revolutions at the time while I was trying to make sense of the legitimacy of the law to regulate liberty in the two legal systems. And I think that her analysis also meets Gadamer in many respects, although of course she doesn't engage directly with him. So to my sense, what is at stake is the relationship and an understanding of the role of the government and an understanding of the role of liberty. And when I mean understanding of the role of the government, I don't mean this is not an issue of strength of the government per se. Many scholars have noted that only a strong sovereign can allow for some liberality in the exercise of the subject's liberty, such as freedom of expression. Adam Smith, for instance, also noted during the 18th century that only a strong sovereign possessing an effective power of coercion can tolerate a degree of citizens' licentiousness. So tolerance in the exercise of liberty presupposes a strong state, and it presupposes a state having effective enforcement mechanisms, which are characteristic of the modern state. So what I think is at stake here is a more profound difference. The understanding of the role of the government on the imaginary level. In the US, it is rarely legitimate for the government to intervene as the regulator of interpersonal respect for harm caused by speech, whereas it is legitimate for the government to intervene in France. And I think that this understanding of the role of the government in France is affected by the organic vision that the Middle Ages inherited from Aristotle, Baudin's, and Rousseau's vision. So the paternalistic role of the state in France has its origins in the attempts by the king to ensure his authority by presenting himself as the protector of the lowest social strata against the feudal lords. And this imaginary determined the conception of unified government. And Jean Baudin and other theorists contributed to this idea of a unity of government. So in the French imaginary dominates an understanding for a strong government that has a positive impact also upon society. And this conception was inherited by the nation during the French Revolution. So ideas of state paternalism, which were elaborated during the monarchy in France, persist in the contemporary understanding of the government. And as Marcel Gauchet notes, during the French Revolution, distrust towards the agents and the holders of political power was the formidable reverse of a faith in its positive character, once it was taken away from those who had usurped it. And I think that those differences in the understanding of the role of the government also relate to the political problems that political actors were facing at the moment of the two revolutions. Historians have shown that the revolutionary impulse in America was a reaction against the legislative activity of the British Parliament, whereas in France, it was the problem of mass poverty. So, and in this context, political theorists have noted that in France, the transfer by the revolution of the king's sovereignty to the National Assembly took place without a qualitative change concerning the understanding of the role of the government, just like previously the mission of the monarchy was to protect its subjects. The role of the parliament would be also to protect its subjects and to help them realize their liberty. In the US, on the contrary, the revolution arose from a reaction against the activity of the British Parliament seen as oppressive and as limiting liberty. The founding fathers implemented the separation of powers in a way that limits the government's impact upon individual liberty. The construction and the organization of the American states, as well as of the federal government, is characterized by a series of checks and balances aiming to control, filter, and overall to moderate the power of the government and its impact on individual liberty. And the judges are also operating in this general context. They think that it is less legitimate for themselves to intervene in defining the content and the limits of liberty, and when they have the opportunity to invalidate legislation, also they do it. If French constitutionalism is founded on a positive conception and a trust regarding the exercise of collective power, the inverse attitude prevails in the American context. It's also relevant to the understanding of rights and the difference that exists in the understanding of natural rights. And we can see a difference also in the relevant debates around the two revolutions. Natural rights discourse emerged in America shortly before the Declaration of Independence in order to legitimize those attempts by the British Parliament to enact legislation limiting the negative liberties of the people in the colonies. In France, there was also a discourse on natural rights, but there were significant distinctions compared to what was the case in the US. So rights were seen as natural because society is also seen as natural and as having the mission to help the citizens realize their rights. And by society, they also meant political society. So according to the dominant conception in France, liberty is to be perfected within society. So liberty makes sense only in society, which amplifies it and makes it meaningful through its laws. So in America, a paternalistic conception of the role of the government did not prevail, like the one which is dominant in Europe. And freedom of speech plays an important role in the system of checks and balances because it ensures accountability and transparency. So to my sense, the understanding of the role of the government in the US is to protect the natural negative rights that citizens have, and freedom of speech is an exemplary negative right. In fact, it's a very important liberty which ensures the protection of all other rights, serving as a check on government, and it enhances the checks and balances of this American system of government. So further, what is at stake here is, I think, two different conceptions in the understanding of republicanism. Both legal and political systems express republican ideas, but in the US, the common good is defined as the need to protect negative liberties. And the dominant conception is that the political sphere is instrumental to the private sphere. The public sphere is only the medium to protect and preserve the private sphere, which is the sphere of happiness. In France, the common good is something we call qualitatively different, and negative liberties are protected only to the extent that they are compatible with the common good. The quality of being a citizen is primary, and the rights of man make sense only as rights of the citizen. So the state has the mission to realize this universal conception of liberty for all citizens, conceived abstractly, and this leads to a wide sphere of government intervention in defining the content and the limits of liberty, and in particular of freedom of speech. Could you remind me how long I have, because I didn't turn on my...
Maybe you can wrap it up in 5 more minutes. Would that work?
Absolutely, absolutely. So I think that all those ideas which I just mentioned are visible also in the relevant text in the American Declaration of Independence, the French Declaration of Rights, in constitutional texts that were created in the various states. But let me briefly discuss how this is relevant to freedom of speech. Let me ground it a little further to freedom of speech. So this understanding of the role of the government also implies a different understanding in the mission of the government to help the citizens realize their liberty. And this is very relevant to freedom of expression, because I think freedom of expression can be seen as a negative liberty, a liberty against the government, but it can also be seen as a positive liberty, in the sense of having met the preconditions that are necessary to exercise this liberty. So, for instance, having the state ensure that citizens obtain access to a variety of currents of opinion can be seen as the positive aspect of freedom of expression. And having access to the media is another aspect of seeing freedom of speech as a positive liberty. And in the US, freedom of expression is protected in its negative sense, but in France, some of its positive aspects are protected too. And I think this is what relates to the legitimacy of the government to define the content and the limits of a liberty. Even the protection of negative liberties requires positive action of the state. So the state needs to make sure that itself and other parties do not infringe the negative spirit of inviolability of the citizens. The protection of positive liberties requires something more. It requires even more extended government intervention. It requires the state to engage in redistributing goods in order to make sure that the citizens will be able to exercise their negative liberties, and that the state will make sure that negative liberties do not remain empty forms, according to the famous Marxist critique. So the state will help the citizens realize their liberty. So in the area of freedom of expression, this means willingness of the state to make sure that the citizens have access to the media, for instance, in the form of a right to respond to publications. It also means that the state intervenes, limiting the rights of others in order to enable others to be heard, and this is relevant in the area of political campaign funding. And the rejection of limits upon independent expenditures during political campaigns by the US Supreme Court in Citizens United means, in my opinion, that the court refuses to see the distinction between formal and real freedom of speech during political campaigns. And the court overlooks that not everybody has the same ability to be heard. Similarly, restrictions upon hate speech in France are dictated by a comprehensive protectionist approach. The state intervenes in order to protect vulnerable groups from hate. It also intervenes in order to prevent the creation of stereotypes against social groups. Those stereotypes mean that in the long term, when those groups speak, are not heard. The burqa ban also in France can be understood as part of this general effort of the state to make sure that citizens enjoy real liberty. The ban was justified in reference to the need to protect women from the oppression of their families, and it was seen as a measure to help them realize their liberty against social pressure, but it was also seen as a measure that helps the women liberate themselves. So their willingness to wear a burqa was seen as part of a false consciousness. So the French state considers legitimate to intervene in order to help those women realize their liberty, to help women realize their reason, because the state considers that they are incapable of realizing it by themselves. And so I engage in the relevant debates around the French and the American Revolution, which show this interplay between government and liberty, and all those debates that indicate what should the mission of the state be to regulate liberty in order to make some normative proposals. I engage also with those various debates. And the argument that I'm trying to make is that the US may be overprotecting freedom of expression in some respects, and France may be underprotecting it. It's important for us to know how those traditions emerged in order for us to be able to think critically. Understanding the ideologies behind the emergence of a legal regime, in this case, protecting speech, does not mean accepting historical determinism. It is possible to think critically and to come up with criteria for limiting speech. Principles which were elaborated in the past in order to meet concrete sociopolitical needs may not be relevant today in order to address contemporary concerns related to limited rights. So to my sense, the reason of the citizens is to be trusted in cases like the burqa ban and the dwarf throwing. But government intervention is legitimate in order to limit hate speech when an individualized target is at stake. And in relation to political campaign funding, again, it is legitimate for the government to intervene in order to affect social power imbalances. Contra Citizens United, the conception of the marketplace of ideas as a sphere of absolute freedom overlooks social power dynamics. So it is legitimate for the government to intervene in order to overcome this distinction between formal freedom and real freedom of speech for some participants in the political debate. So I hope this provided a comprehensive presentation of the key ideas in the book, and I very much look forward to the comments of the participants.
Thank you very much. I have to say, I find my role here a little bit frustrating because having read through the book, I have an enormous number of things I'd like to say, but that is not my position, unfortunately. So I'm exercising considerable self-restraint here. I think we'll just go in the order in which names are listed in the program, unless someone objects. And so Professor Whitman from Yale will be the first commentator.
I now feel I should yield my time to you, Howard. I don't know, but
no, you don't have that option.
But I'll try to leave plenty of time for you to intervene later. So Ioanna's book is extraordinarily learned and wide-ranging. She's read a remarkable variety of historical and philosophical literature and brought it all to bear on her topic. It's impressive, I guess is the right word for it. And I do want to say, by the way, that if I guess addressing myself to her, that your concise account of what's going on in the book is impressive too. Most authors can't actually pull that off, to take 20 minutes and explain what they've said in a difficult book. So good for you. I'll say, I want to pick up where you left off on the normative question here. Because in reading the book, I was inspired to, I guess I'd say, normative concerns, normative anxieties, involving questions that you don't directly address, that partly involve free speech, but in a broader sense involve, I guess, what's the announced topic of this panel, which is how we should think about the two great revolutions here. And I'll justify talking a little bit more broadly about the two great revolutions just by reference to your own book. There's an awful lot in the book that never loses sight of the free speech, free expression questions, but that takes us very, very on a much, much more extensive journey through these revolutionary traditions. the great question posed by the book, I think, and I will say a little more about some of your examples in free expression, is how we should think, as you say, normatively about these two revolutions. And here I'd like to start with an author you mentioned, who is Hannah Arendt, and another author whom you cite but don't mention much in your text, or talk with you, who is J.L. Talmon, and discuss their attitudes and whether their attitudes are attitudes we can still bring to the questions that you raise in the book. Now, let me say, first of all, that it's not obvious that one would take a normative attitude toward this material at all. One could cite Gadamer, as you've done, just talk, as I've done in my own work, just talk about the different Vorverständnisse, the prejudices, and try to understand why these different legal orders take the form that they take, without ultimately suspending value judgments, or at least maintaining, as comparative lawyers tend to do these days, that it wouldn't really be possible to transform either of them, certainly not through transplants, and maybe more broadly, that all we can really do is engage in the enterprise of trying to understand them. That's been much my attitude. I think, I'm not sure after reading your book and experiencing the last few years in the United States that that's an acceptable attitude. If we are going to engage in value judgments, in normative reasoning, as you say, how should we think about the normative stakes here? Hannah Arendt, or let me start with Talmon. Talmon and Hannah Arendt were both writing in the early years of the Cold War. So Talmon in the 50s, Hannah Arendt, I think I looked in 1963. And I'll say it's a long time since I've read both books. So if I get them wrong, chastise me. Both of them were concerned to explain what was, after all, the pressing question of the time, the horrors of totalitarianism, and at that time, in the mid-1950s, the early 1960s, what was going on in the communist world. The claim of Talmon, as I think we all know, or at least I thought I knew in graduate school, in The Origins of Totalitarian Democracy, was that the French revolutionary tradition, particularly in its indebtedness to Rousseau, which you also emphasize, I'll say parenthetically, I'm not sure entirely persuasively, I'm not sure that all historians of the French Revolution would believe that Rousseau played quite the dominant role that you're making him out to have played in the book, but that's for another discussion. It's not critical here. But Talmon's view was that exactly what you're describing, the organic view of society, the notion of the collective will, the tolerance of the exercise of state power, however attractive they may have seemed, and they didn't always seem perfectly attractive during the French Revolution, had given rise to a very, very dangerous long-term revolutionary tradition, which had to be resisted. Hannah Arendt, in particular, pointed to the American Revolution with its more pragmatic, more individualistic orientation, with, if you like, its more nominalist orientation, its emphasis on individual autonomy. She pointed to the American Revolution as offering the much more attractive model. She was in exile in America, of course. And I think circa 1963, it was more than plausible to think of the world that way. And you know, when I was younger, it was plausible to think of the world that way. Given the events of the last couple decades, and especially the last 5 years or so, I'm no longer ready to think in those terms myself. I think that what we're dealing with in American history now and in global history more broadly really demands that we revisit what seemed so obvious to Hannah Arendt in 1963, or to Talmon for that matter in 1950, not because I'm coming here saying we should be endorsing either Stalin or Mao or anything like that, but because the attractiveness of the American model is not quite as evident as it once seemed to be. Now, the question I bring to your book is whether that, to me at least, but I imagine to most of us, extraordinarily pressing, problematic, oughtn't to play a role, not just in your account of what you're discussing, but more broadly in what the field of comparative law is up to. Oughtn't we, as a field, to be responding to this extraordinary crisis, which I think you're right in saying, in important ways, is a crisis of the American revolutionary tradition, and a little bit more broadly of the Anglo tradition, since after all, American revolutionaries were drawing on a broader Anglo culture, and since, of course, the problems are also seen elsewhere in the Anglo world, in which in an odd way you're teaching, although how Ireland fits in is, something that deserves another discussion there. As I read your book, I thought, boy, we really have to start thinking hard about these two revolutions, and we have to think about what comparative law has to say about them. Now, I mean, that's not what you're up to. It's not appropriate to ask that you do it, but I think the question is raised and it's important to at least begin to discuss it. Now, you end with a kind of an Americanizing normative take on these things. France goes too far. We should do the American thing. I'm not completely unsympathetic to that view, although, as you may know from my own writings, I've been more skeptical that we can just make France like America or America like France. It hasn't seemed to me a particularly practical question that comparative law might pose. So I haven't been that interested in posing it, but to the extent it can be posed, as you can imagine from what I've just said, I'm resisting. I don't know how deeply integrated what you're describing as the American culture of free expression is in what seem like the frighteningly dubious aspects of this American revolutionary tradition now, but I think we have to worry about it, and campaign finance is a natural place to start worrying. So I guess the first question I want to pose to you is that, shouldn't we be worried about that, perhaps notably in the case of campaign finance, but not only? After all, it's easy to view the troubling departures from sane governmental practices that we witnessed in the last couple of national elections as reflecting in important ways American traditions of free expression magnified by American social media. I'm hardly the only person to worry about these issues. I don't see how in this historical moment a book about free expression can't worry about those issues. And I don't see how a book that takes your extremely wise approach, namely looking at the deeper revolutionary background to them, can't worry about the deeper revolutionary traditions that lie in the background. I have comparable thoughts or similar thoughts with regard to some of the rest of what you say. So, for example, the dwarf throwing. Now, was wonderful business, of course, for teaching and for discussion. You treat dwarf throwing as a free expression question, and of course, it can be treated as a free expression question. But I'd be inclined to treat it a little bit differently in ways that I think might offer us possibilities for discussing the big issues about the value of these revolutionary traditions and what's grown out of them. The dwarf throwing decision in France, and this in Germany also has dwarf throwing, I assume is involving the same dwarf, decisions on the same topic, reflect, to my mind, an orientation toward what German laws, I'm sure you know, calls the necessity of respecting an objective order of values. There's an objective order of values founded in human dignity. The interests or claims or demands of subjective right involved, the desire of the dwarf to be thrown, the desire of the people throwing the dwarf to throw the dwarf, none of those bear if they violate the objective order of values in question. Now that seems to me a starting point, not the only starting point, but an important starting point for talking about the comparative differences here, because of course, the first thing we would say about American law is A, that it doesn't have an objective order of values based in human dignity, because it sure doesn't, but B, that it doesn't have objective orders of values at all. I would object to the second contention because I think as we look closely at American law, for example, at insider trading law and other things, we discover that there is an objective order of values. The objective order of values has to do with maintaining the functioning of the free market, which paradoxically often does involve disregarding the subjective rights claims of the people involved. So that the question, as we're asking about these two systems and about their place in modern history, is partly a question about the contrast between those two different understandings of what the fundamental objective order of values might be in a modern legal order. And I think presenting it that way, I'm just suggesting, can lead to the kind of normative discussion that I'm desperate that we have in the field. How the American Revolution or the tradition has landed us in this extraordinarily frightening dilemma in which we find ourselves now in the United States. I'd say similar things possibly about another of your examples. You point to something that shocks Americans when they see it. That is the phrase appended to the end of the list of the various lists of rights. in the Declaration of the Rights of Man and the Citizen in the France as determined by law, with its implication that the state might in some way alter rights. Now, as you know, but I think don't emphasize in the book, there is a way of understanding that phrase, that proviso, that it invites a more sympathetic discussion of things. The point of the phrase is to insist on a French revolutionary tradition of legality. What it means is that laws must be laws, as you say, of general application. They must apply equally to every person, and the requirement that they apply equally to every person, including legislators and including persons highly placed in society, is the guarantee that a norm of equality will be respected in the society. Now that, what's called legality often enough in the European tradition, that norm of legality is not perfectly respected in Europe, maybe least of all in France, but it's very dramatically not respected in the United States. And I would say it's more not respected in the United States. So that the absence of this on its face state-heavy approach to the interpretation of the law, to the interpretation of rights in the United States, has, from that point of view, if this is the right way of describing things, played its own role, if only a minor role, in what's going wrong today. Now, all of that could be wrong, but it's an invitation to you to talk about what's going wrong today, and a kind of cri de coeur for the field. We gotta find a way to talk about what's going wrong today, and one way of stating the dilemma is to recognize how unpersuasive Hannah Arendt's views in 1963 now seem. So I'll stop there.
A very strong note on which to stop. Ioanna, my inclination is to let each of the designated commentators speak and then ask you to respond to all of them and then open the floor rather than having you respond to each one seriatim. Is that something you're comfortable with?
Absolutely, yes.
Okay. In that case, the next person up is Professor Kay. The floor is yours. Reminding you, you have 15 minutes for larger values of 15.
Perfect. Thanks a lot. I'm very happy to participate in this program, partially because it is, as Tim Sellers mentioned, a kind of a celebration of the success of the series in comparative law that the American Society has sponsored, and which Tim, by the way, must take much of the credit for. And also because it has to do with the work of my friend and colleague Ioanna Tourkochoriti, who has been, in addition to being a formidable scholar, she is also a great citizen of the American Society. Let me talk a little bit about the book. There's kind of a cardinal rule in comparative law scholarship that we have to pay attention to the background facts in jurisprudence that we are comparing. And at the top of the list of facts is the political and intellectual environment in which the law is being studied, is either created or applied. But the truth is that sometimes we don't do that so carefully, or we skip it all. Ioanna's book is a model of scholarship that takes that obligation seriously. She has made what we call these days a deep dive into the prevailing intellectual currents in the revolutionary and constitutional periods in which attitudes towards constitutionalism in these places were forged. And she's followed the implications of those currents into the legal artifacts created then and later. And as you probably already gathered from her summary, she paints a very stark comparison between French and American attitudes towards the purpose of constitution. Her jumping off point is this observation about American and French constitutional decisions concerning freedom of expression. That in France, official limitation on expression is tolerated much more broadly than it is in the United States. But as I read the book, this distinction simply provides Ioanna with the occasion for engaging in a much broader exploration of the two 18th century revolutions and constitutional founding. Now, her descriptions are very full, very detailed. They certainly do justice to the nuances in each case. But let me simplify, I suppose I should say, let me oversimplify by saying she finds that Americans following Locke and similar thinkers saw the state as a unique source of risk. That is, personal fulfillment, personal welfare develops mainly outside of official civil society. So the state has only the very limited purpose of reconciling conflicts when they arise, and it is restricted to protecting individuals in the exercise of their natural rights. This attitude is concisely summarized in the most famous sentence in the Declaration of Independence. We hold these truths, et cetera, et cetera. Putting the point slightly differently, on this American view, true liberty is something fully realizable, maybe only realizable, independently of organized political society. So more state inevitably means more risk. I quote what Ioanna says in the book: the American political system is founded on the metaphysical postulate of distrust toward the government. In France, on the other hand, the state, insofar as its institutions incorporate the general will, was thought to be well suited to make correct judgments about individual conduct. Civil society alone is incompetent to deal with the dangers created by personal activity. True liberty in this case is realizable only as part of organized society. Liberty is something, and again I quote from the book, dependent on being enacted by the state. Human beings, that is, are imperfect, and it's the job of the collectivity to manage and to improve. The function of legislation is not just regulatory, it is also pedagogic. So the book paints these two dramatically different pictures of the function of the state, of liberty, and in fact, of human nature. The differences between these two worldviews are painted so drastically that I was initially skeptical of the comparison. The constituent events that are being compared, after all, occur roughly contemporaneously. The difference between 1776 and 1793 is nothing but a blink of the eye in the long course of intellectual history. And the Atlantic Ocean was, in fact, a lot bigger then than it is now. But we know that transatlantic intellectual exchange was active and productive in that period. We know, for example, that the American founders were deeply interested in European models of government and in European political thinkers. We also know that the American example did influence French Constitution. Jefferson famously not shy about offering advice to his French Constitution friends. So when the Declaration of Independence in 1776 refers to people being endowed by their creator with certain unalienable rights, and the French Declaration of 1789 refers to natural, imprescriptible, and inalienable rights, we figure they're talking about the same thing. But the evidence that Ioanna has assembled to the contrary is pretty convincing. That evidence consists of remarks in the various revolutionary assemblies, and statements in the published writings of the main revolutionary actors. So as early as 1789, we see French statesmen speaking in the National Assembly and talking about what we would regard now, I think, as an ambitious and remarkably ambitious role for the state, one that far exceeds the limited state that Americans were contemplating at that time. It appears in the speeches of members, even that we think of as moderates like Sieyès or Mirabeau. But these include explicit statements insisting that their revolution, that the French Revolution, was something quite different than the American. The book also adds a further explanation by pointing out quite reasonably that the two societies we're comparing during the pre-revolutionary period had gone through very different social and political experiences. We might also say that the differences are confirmed by what happens after these revolutions. So in the United States, we have the Constitution, and in France, the Terror and the Empire. And although like the French, the American Revolution could be said to be premised on the values of liberty and equality, it takes, I think, a bit of doing to see it as an exercise in fraternity. Now, it's true that both of these revolutions emphasize the importance of people in legitimating new governments, but they probably understood the people in different ways. In France, once the revolution is accomplished, the supreme powers of the people are seen as absorbed by the legislature. And the Declaration of Rights is clear that the governmental authority of the people could be exercised either personally or by their representatives. In the United States, on the other hand, the distinction between the people and the state is absolutely critical. And it is permanent. That is, the people exist apart from and are superior to their representatives. And the way the people speak is by making or unmaking a constitution. This is, as we know, also the idea that has been put forward as justifying the judicial power of constitutional review. But in the United States, in the American tradition, the people are also presumed to be standing by and able to reassert their ultimate authority at any time. Again, this is clear in the language of the Declaration of Independence, and especially in the early state constitutions, and indeed to this day in many states. Actually, there is something rather like this in the 1793 version of the Declaration of Rights, which goes so far as explicitly to guarantee to the people a right of insurrection. But unlike in the United States, France created no institutional mechanism other than the elected legislature by which this people's will could assert itself. And as a reflection of this, in France, judicial review of legislation, whether based on the Constitution or anything else, was expressly forbidden by law until well into the 20th century. So I think that that Ioanna's book makes a very good case that there really was a fairly radical distinction between the reigning philosophies of the two revolutions. And yet, and this is the point on which I will conclude, I wonder if the differences in the modern free speech jurisprudence in these two constitutional is really explicable by the very different traditions arising from the different 18th century revolutions. For one thing, the French Constitution have not been entirely toothless in protecting individual rights against the state. And that even though the institutional setup has not given them much scope for application. In fact, just last year, a proposed statute which limited online hate speech was held by the Constitutional Council to be unconstitutional. And more generally, we have to wonder about the practicability of showing any clear link between revolutionary developments of the 18th century and the modern behavior of the Supreme Court and Constitutional Council. It is certainly true that various decisions of the Constitutional Council have upheld restriction on expression that would most probably be held invalid by the US Supreme Court. And this difference is just what we would expect if the prevailing constitutional philosophies were different in the way Ioanna has depicted them in the Revolutionary. But this is a logical and not a historical. Proof of the latter, proof of the historical cause, has to contend with the very significant gap in France of 150 years or so between the founding of the Republic and the initiation of constitutional review based on the Declaration of Rights. So much else happened during that time that might be interpreted as alternative explanations for the differences in the decision. And this temporal gap between founding and judicial judgment is equally problematic when we were evaluating explanations for the libertarian decisions in the US Supreme Court. Again, a lot of water has passed under the bridge between the days of the Declaration of Independence and the speech protective decision of the Supreme Court. That is the 18th century distrust of the state that the book describes is unlikely to be the only or even the most important influence on decisions of the Supreme Court. And this is illustrated by a puzzle in US constitutional history that Ioanna mentions. The picture of the proper definition of public and private spheres that develops in America at the end of the 18th century might well be hostile to government regulation of expression, but it would seem to be equally unfriendly to state interference in private economic transactions. And though that attitude, of course, did show itself in US constitutional law at the end of the 19th, beginning of the 20th century, it kind of petered out in the second half of the 20th century. That is, at just the time when the aggressive of intellectual and expressive freedom comes into its own. So we have the kind of schizophrenic application of that philosophy, which we live in today. This is the state of affairs, neatly packaged in the famous footnote 4 of the Caroline products. Let me stop. I'll just say that these questions that I've raised about the book's thesis are, I think, themselves a tribute to the stimulating nature of this book. This book is a formidable contribution to comparative intellectual history. I am certainly far better off after reading it, as will be anyone who's interested in the character of these two founders. Thank you, Ioanna, very much. And thanks to the Society for creating this opportunity.
Okay, Professor Tushnet, please take the floor and share your thoughts with us.
Thank you. I want to begin by saying something to the entire audience that I mentioned in the sort of pre-conversation, which is that I have encountered this project for not as long as Ioanna has, but for quite a long time. As I was cleaning out my office, I think it's now 6 months ago, I discovered a copy of the dissertation that is the ultimate source of this book. And I mention that because having seen the book develop over time, my take on it may be, take on the final version, may be unduly influenced by things that were transformed as it was further developed. So that's a cautionary note. I want to make 2.5 points. The first is about the work situated in the, I don't know how to put this, a field of comparative scholarship about comparative law. And the second is a substantive point that I will get to related to one of the themes that I'll talk about in connection with the first point. So the main components of the book's argument are, in my view, twofold. First, there is a historicizing move, that is to identify traditions of constitutional thinking that originated in the early years, the two revolutions, that continue to work their way through constitutional doctrine over the succeeding 200 and more years. I'm actually not going to say very much about that historicizing element, although my half point is relevant to it. The second main component, and this is the one that I want to focus on, is a attention to philosophy, the foundational philosophical, grounding of ideas about human liberty, dignity, expression, and the like. Towards the end of the book, Ioanna quotes, he's here, so I will quote it as well, William Ewald, that comparative law is an essentially philosophical enterprise. And earlier in the book, she talks about how what she's dealing with are, I would put it, specifications of or particular examples of different conceptions of the state and government. Now, one observation I want to make here is that the use of the term state in this project locates it in a certain kind of scholarship that I, for convenience, will associate, this is not completely accurate, with a continental tradition of constitutional scholarship. And that brings me to my comparative scholarship point, because one thing that would appear more prominently in a work by someone coming from the US constitutional tradition would be attention to what Professor Kay mentioned in passing, the institutional forms in which these both historical traditions and philosophical ideas get, to use Richard Fallon's terms, get implemented. And so the state is significant here because in the United States, that term is ambiguous. Does it refer to the government in the large, or does it refer to the 50, whatever number you want to use, subnational governments that we call state governments? That's an institutional feature of the US. Now, I want to say, before elaborating just a little bit on this, that the difference between what I'm calling the continental tradition of comparative scholarship and the US tradition of comparative scholarship is not night and day. Both forms of scholarship include attention to what I've been calling the historicized analysis, to foundational philosophical analysis, and to institutional concerns. But in my view, I think this is a common observation in the field of comparative law, the sort of balance among the three differs in the two traditions. And Ioanna's has the more historicized, more philosophical, less institutional feature that I associate with, again, what I'm calling the continental tradition, and the way I think about it, these issues, has a much greater focus on institutional matters. So just to indicate what is, I want to put this, underemphasized, not omitted, but underemphasized. There is, in the first instance, there's federalism in the United States. Now, one of the consequences of federalism is that there are many decision makers who are charged with enforcing whatever regulations their jurisdictions come up with. And the doctrinal constraints that you will be inclined to develop will be different when you're dealing with 1,000 prosecutors around the country, most of whom are elected, compared to what you're dealing with in a tradition where prosecutors are a bureaucratic civil service operation unified at the top. You'll want to have different doctrinal resolutions for that. And I think some significant aspects of US constitutional doctrine are affected by that fact. A second institutional point is also related. In the United States, much of the time, decisions are relegated to either elected prosecutors, elected judges, or randomly selected groups of citizens known as juries. That's an institutional feature of these free speech law and law of human dignity and the like. In France, the relevant decision makers are not of that sort. The prosecutors and judges are, again, sort of bureaucratic and have imbued a kind of orient themselves to a kind of tradition that US prosecutors and judges don't always orient themselves toward. And then just finally, and this is something that Richard mentioned in passing, it's only until recently it's not until recently that France in particular had what's not even yet a robust system of constitutional complaints of the sort that the US has had for quite a long time. And France has had, again, for some time, depending on how you treat the Conseil d'Etat, it's had a much more robust tradition of pre-enforcement evaluation than the US has had. And again, I think those institutional features have some effect on US doctrine. Now, I don't want to get into the details of the doctrinal stuff. What I do want to note is, again, the comparative scholarship point. And just, I'll wrap this part of my comments up with the observation that, and I think this is really banal, one reason for the difference is, again, to overstate things, the quite different role of scholarship in continental traditions and the US tradition. The overstated version is that constitutional scholarship in the United States is, for all practical purposes, marginal to the development of constitutional doctrine, whereas in France, constitutional scholarship is integral to the development of constitutional doctrine. And that gives different incentives to the kind of analysis that scholars engage in. Okay, my second point is more substantive. And it comes in, hasn't come up in this discussion so far in much detail. Ioanna's discussion of the relative role of civil society versus the state. Now, part of her argument is that some of the work that's done in France by the government is done in the United States by civil society. So in particular, civil society organizations and groups in the United States offer critiques of practices that would be regulated in France. Just one footnote here, since I think this is actually an example. I'm actually uncomfortable with the term dwarf throwing, but there's no other one available. Jim Whitman mentioned, and Ioanna talks about the French case. Jim Whitman mentioned a German case. In the United States, there's a depiction of dwarf throwing in the film Wolf of Wall Street. And it's, the Wolf of Wall Street qua film is a version of a civil society comment on the practice. It's a complicated comment, but it's there. Okay, now with respect to this idea that the state and civil society are performing not the same, but similar roles in the different nations, I do want to note one point, which is which blurs the distinction, that in connection in particular with free expression, but maybe in connection with other things, part of the US discourse is to treat civil society actors as if they were sort of government actors, because they are regulating, in this context, speech. So, you know, Twitter, Donald Trump is kicked off of Twitter. He says that's a violation of my free speech rights. The fancy people, like me, say, oh, come on, it's a private agency, it's civil society, it doesn't, not subject to the regulations that are the government's subject to, or the discussion of the cancel culture as a matter of concern for free expression purposes, for the vibrancy of a culture of free expression. The cancel culture is a civil society mechanism. And so it seems to me that the distinction that Ioanna draws, which again, I want to say has some force, is blurry or can come under pressure depending on a set of social circumstances of the sort that I guess Jim Whitman wants to describe as the looming constitutional / social crisis in the United States. Looming, it maybe is not a word, the crisis we are currently experiencing in the United States. Another way of putting this in this, I'll end on it, is that if you have a world in which, an overall world in which you agree that in which there ought to be large agreement, that certain kinds of behaviors should be disfavored. And in France, those behaviors are disfavored by the state. In the United States, they are protected by the state. But in Ioanna's analysis, the vehicle for disfavoring them is civil society. But if the disfavoring these practices by civil society comes under pressure, then you're in a very bad situation because this stuff that as to which there ought to be agreement should be disfavored, can't be disfavored by the government and can't be disfavored by civil society. And so it's going to proliferate. Thank you.
Thank you, Mark. Ioanna, I think we'll give the floor back to you to respond for a bit. Please don't take more than 15 minutes so that there'll be some time for others, to get in on this discussion, which is obviously extremely provocative and potentially valuable. So please.
Absolutely. Thank you very much. So I think I will start with Professor Kay's comments, because he articulated some very interesting criticism as to why what happens, why, let's say, some intellectual debates that took place 200 or 300 years ago are still relevant today, and why do they help us make sense? And they really help us make sense of the understanding of legal and political actors as to the degree of the legitimacy of the government to regulate a liberty over another or not. So I think that it's not a coincidence that those major US Supreme Court decisions that establish this strict doctrine of protection of free speech refer to those debates. And this is what is motivated me also to look into those debates. This indicates, in my opinion, a sense that at some moment in history, say during the middle of the 20th century, some precise sociopolitical factors lead legal and political actors to realize that maybe this is the doctrine of freedom of speech that is more consistent with our constitutional tradition. Therefore, the need for them to refer back. I think that, so what I'm trying to do is not so much, I'm not trying to offer a historical interpretation, I'm trying to offer a political theory interpretation, right? So which are the most important political theories that underlie the understanding of legal and political actors. And if constitutional actors feel at some point during the 20th century to refer to those debates, then those political theories that were articulated there were relevant, and maybe they help political actors later on understand better their meaning and draw implications that political actors maybe so far were not in position to draw, at least in the area of free speech, because during, let's say, the 19th century, I don't think we have anything significant at the federal level in the area of free speech. There is something at the level of the states, and I think the doctrine there wasn't all that different. I think that at some point, there was the mentality of the British common law that was introduced, and courts would accept limitations. I think David Raban has written an extremely interesting book on free speech in its forgotten years, and there he makes the point that during the 19th century, courts would actually limit speech. So it's during the 20th century that courts decide to articulate this libertarian protection of free speech, and this is due to the fact that maybe there is something else that is taking place. It's during around the same time or a little earlier that it became legitimate for the general government and the government in general to intervene and regulate the area of the economy. And I think that the New Deal and its aftermath actually catalyzed the emergence of this doctrine of free speech, because from this moment and on, free speech emerged as the area of law which would express this distrust towards the government. And it's the Caroline Products, I think, is a very significant decision in this respect. So those ideas that existed there in the background became extremely relevant during the 20th century. And there are other reasons that were also relevant, and other historians, American historians, who have been studying American history have been pointing out. Laura Weinreb discussed those debates that took place around the New Deal era. And at some point, the protection of free speech seemed to be an extremely convenient doctrine for everyone, for, let's say, the workers who were protesting, but also for their employers, for the owners of the mass media as well. So this was a doctrine which emerged because it was the common grounds on which a very, very broad part of the civil society in the US would agree. And other historians have pointed out, have offered different interpretations. So what I'm trying to say is that it happened at this moment, because at this moment there is a much older tradition that obtained a new significance. And I think that it is relevant for us to discuss this older tradition. And then in France, the French Declaration was a declaration that didn't really apply, that wasn't really implemented until, again, the middle of the 20th century. Nevertheless, it always expressed some values that the French considered very, very important. So why didn't it become law earlier? Because the French Revolution failed. And Hegel is offering us extremely interesting insights. It aimed too highly, it imposed abstract ideas upon reality, it was bound to fail. It resulted in this fury of destruction, resulted into the terror, political instability. What was the way out? Napoleon, a plebiscitarian monarch who recognized some liberty, enacted the civil code, but he tried to draw some legitimacy through plebiscites every now and then, but he ruled in every other respect as a monarch. Right? So when the French society obtained the maturity to establish a working democracy, the French Declaration again became the constitutional text that expressed the most important values that the French people consider important. So Georges Vedel, an extremely interesting and important professor of constitutional law in France, has written that it was the text that expresses some existential values that the French society accepts. And therefore, I think the importance of actually looking again into those debates. This text is the result of an intense intellectual debate around the moment of the French Revolution, where you have an assembly which asserts itself as a representative parliament and is trying to articulate new rules as to what is the mission of the state and what is the proper understanding of liberty. And then to Professor Tashnut about the intricacies that exist in the US between the federal and the state government, and maybe if we look into those intricacies and the interrelationship between all those levels of government, maybe we are led to a different understanding of what is really happening. I think it is significant that sooner or later the Supreme Court has the last word in the area of liberties. So, and it's very likely that legislation that may apply in many states is not enforceable under the standards that the Supreme Court has articulated in the area of free speech. But apart from this, I did do a research on the understanding of constitutionalism that emerged at the level of the states around the founding era and even beforehand. And then I realized that this idea that there should be a control of legislation in reference to some other higher standards existed even then. And it's actually James Otis, an extremely important figure. So this is part of research that I did well before, well after the defense of the dissertation and the version of the text you saw. So James Otis was an extremely interesting thinker who is one among the first who articulated the fact that the law must be compared in reference to some higher standards, some other values that are above legislation. And so even before the Declaration of Independence, even before the foundation of the various states in the US, there was an understanding that the law is inherently dangerous and that there must be some standard in comparison to which in reference to which it should be evaluated. And courts actually everywhere at the level of the states, even before the Declaration of Independence, would engage in this type of control, which is something like a judicial review, but not really, because there wasn't really a text. Everything was done at the level of values and principles at the time. In France, at the same time, there wasn't even a parliament which would enact legislation. So in France, the law is extremely important. It's an extremely important instrument because the French Revolution at the time aimed to reconstruct society itself, and the law, which would apply equally to everyone, would help it accomplish this mission towards, let's say, eliminating a regime where the monarch would just enact legislation and this legislation would apply unequally. So we see this tension where, on the one side, we have a tradition of constitutionalism emerging, where the law is actually to be measured in reference to some higher standard, and in this other tradition of constitutionalism, the law is to be the standard, because actually coming up with laws that are general is a sign of constitutional evolution. There's a profound belief that it will improve the state of constitutionalism and, of course, the lives of the people there. And then so I will come back to Twitter and Facebook and this interplay between civil society and the state, because there we need to take into consideration also the transnational element of those activities. I think I should engage with Professor Whitman's comments in relation to the comparison and the criticism of these two revolutionary traditions. An argument that I engage with indirectly, that I make there indirectly, is that in those parts of the world where the constitutional tradition allows for government intervention within civil society and allows an extending welfare state, so where it is legitimate for the state to engage in economic redistribution, it is also legitimate for the state to help the citizens realize their liberty in the sense of making sure that the citizens have what they need in order to be able to exercise their negative liberties, but also define the content of their liberty itself. And I think it is this element that is particularly relevant for freedom of expression. So the state will liberate the women who want to wear burqas because they do not know that they are unfree. So just like the state will engage in redistribution and will provide a public healthcare system. But I think this should be the product of my second book, a more critical approach to those two revolutionary traditions in the area of welfare rights and in the area of healthcare, possibly, which is also relevant in relation to the pandemic, but also to the civil society social unrest that allows politicians like the former president in the US to be elected. And I think it's extremely interesting to read that the current president is trying to enact measures that engage in redistribution, but he feels the need to present those measures and to package those measures as a set of measures that are necessary in order to improve the infrastructure of the market. And so care is presented to be as an element of the infrastructure of the market. In Europe, the government would just provide care, would just provide public health care to the citizens because it's obvious that this is something, it is a mission of the government to do so. There are complaints as to how this is done, but everybody takes it for granted that there should be a public healthcare system. So if this tradition of distrust towards the state in the US maybe is going too far, occasionally we see the state engaging in economic redistribution, and we see it again after a crisis, for instance, the New Deal, after the 2008 crisis, today again. This is what the current president is trying to do. So every now and then we see some kind of attempt, but those attempts are short-lived. Sooner or later, political actors are elected, judges are appointed, and legislation which engages in redistribution is invalidated, and the measures are limited again, are held back again. So maybe I think that I should write a second book engaging with those philosophies again in the area of the welfare state and be very, very critical of this tradition of distrust towards the government, because I think that this distrust towards the government is what has led to civil society unrest. And maybe this tradition that exists in Europe, that it is the mission of the government to engage in redistribution and provide healthcare, is preferable to a great extent. And this also leads me to the comment in relation to Twitter and Facebook, civil society actors, which impose limitations. Today, yes, they do, but I think that they decided that they had to in the US because of the transatlantic nature of those activities and because several cases had emerged in the past before those committees were established, which would define some standards of permissible behavior, where French authorities and European authorities were asking them to provide elements of identification of people who had engaged in hate speech, and both those companies would refuse. In reference to the First Amendment, this is protected activity in the US, engaging in hate speech. We have no obligation whatsoever to provide elements of identification of anyone who engages in hate speech. Because those platforms transcend the boundaries of the US, this behavior sooner or later became unacceptable in Europe, and they were forced. So the EU itself established a deontology committee, and Facebook had to replicate and create its own deontology committee. So I think that this is due to the influence of Europe, and I think that we should definitely be thinking about the proper standards that those committees have been establishing. So this is a gap of regulation that exists in the US, which allows a civil society actor to self-regulate. But are those standards that this actor, this committee imposes acceptable? Are they going even further compared to what would be acceptable even in Europe by European standards, where the state itself enforces limits upon hate speech? I think this is something that we should be doing research on in the future, finding the right balance and finding appropriate criteria of limiting speech in this area. So I think I should stop here because I took quite some time, and maybe we can come back.
Right, so unfortunately, we have only 20 minutes left, but please, let me open the floor. You can use the hand raising function or just wave if I see you. I'll call on you. I'll make one comment. Just Tim Sellers and I recently had an exchange, which I suggested that the higher law constitutionalism tradition goes back to Massachusetts in 1641. Professor Sellers disagreed vehemently, but I will leave that debate for another time. Yeah, yes. Tim. You have to unmute yourself.
Since I was mentioned and since there are no other hands, I had a reaction to both to Professor Tourkochoriti, but also perhaps to Professor Whitman on a point about which I think they agree. And I just wondered, I wanted to get the reaction of the author and perhaps provoke some talk among the panelists. But I wonder really if this libertarian approach that we're characterizing as being a product of the 18th century United States constitutional tradition is in fact really a product of the 18th century United States constitutional tradition, or whether it is the product of the opposition to that constitution and really emerges from, I don't know, you might say the Andrew Jackson philosophy of law, or some of these Southern theories of law that are really, in other words, that our own revolution, the 18th century revolution, was a Republican revolution, and in that sense had something very much in common with France. And that this extreme libertarian position on a number of things really emerges from the, might call the anti-federalist tradition, the Southern states' rights tradition, these various traditions that were oppositional and that have crept into modern United States constitutional opinions, but really arise in opposition to that tradition.
Yeah, I'm going to actually just add a point on that, if I may. I don't want to take up time. But when the description of the American Revolution is a purely Lockean liberal enterprise, and the description of the French Revolution as a Rousseauian Republican enterprise, really has not stood up well since at least the historiography of the 1970s and onward. Just to take a couple of really fast examples, Jefferson was quite eager to have states shut down newspapers that criticized his administration. Adams thought sumptuary laws were absolutely essential to the maintenance of a good, and that's he's written that in 1776 in Thoughts on Government. He's perfectly willing to consider experimentation, whether there should be a Congress or a president or a king, but you have to have sumptuary laws. Those are necessary to maintain virtue. So I think that in my view, at least, the comparison to the French and the American approach to free speech is a strong one, but I'm much less persuaded by the idea that it has these deep intellectual historical roots. I think the libertarian attitude toward free speech in the American constitutional tradition is very much a product of the 1980s, and at which time we did a lot of rewriting of history in the way we talked about our earlier revolution. So I'm just piggybacking on Tim Sellers' comment to sort of more or less the same effect. Ioanna, you can respond, or if there are other hands?
Yes, I think that some elements existed already during the founding era, right? The Cato's letters were extremely interesting and very influential, and they discussed freedom of speech, and they emphasized freedom of speech as an extremely important freedom. And then again, the idea of distrust towards the government, I think, was established in the US well before the French Revolution, thanks to this tradition of constitutionalism that already started to emerge. But also, it is visible in the Federalist Papers, because the way I read the Federalist Papers is that I see an intellectual effort to persuade that the central government is necessary to defend the state from external enemies. But the whole point of the Federalist Papers is to persuade that this government will not degenerate in tyranny, because the Americans had declared independence against a strong centralized government in the first place. Why would they need to establish something something similar. And the anti-federalists, so those, the University of Chicago has come up with a collection of all those papers. So they were also putting forward arguments which refer to those natural rights that people have, and the most important of those natural rights is the right to freedom of expression. And the authors of the Federalist Papers felt the need to justify the creation of a federal state, which would be permeated by checks and balances, and which serve well the mission of protecting the state from foreign dangers. So it would create a strong, effective state, and this is something that Max Edling and Steve Pincus have also noted. So it's extremely important to create a state, but it was extremely important also for them to persuade that this state didn't have, would have all the mechanisms, let's say, that would prevent it from degenerating into a tyrannical state. And therefore the idea of checks and balances, and therefore if there Madison using Montesquieu and pushing Montesquieu even further than what Montesquieu had said. So Montesquieu's opinion was that the separation of power is important, and all we need to have is just different actors incarnating those various branches of government. The idea that there should be one branch of government which would pose limits upon the other two is Madison's idea. And I think that the Federalist is permeated by similar reflections which indicate that there should be a limit upon the government. And this is why they were written in the first place, I think.
But the national government had nothing to do with free speech. This was all at the state level. And many of the states were highly intrusive and highly willing to intervene in civil society. And let's go back to Mark Tushman's point. This doesn't become a federalized question until at least the 1920s. I'm sorry, I should leave the floor open to other people.
Absolutely, yeah, but I'm indicating a political tradition. This is an interpretation at the level of political theory. I think that those ideas are extremely relevant and can help us make sense of why, during the 20th century, this doctrine emerged and was established.
Other thoughts? Seems like an awfully provocative set of arguments to be inspiring so little conversations. Someone at least.
Professor Ewald.
I beg your pardon?
Sorry, I've got my hand up.
Oh,
Though it's not directly.
of course. Please.
So this sounds like an absolutely fascinating book. Obviously, I've not read it, so I'm reacting to the commentary on it, but I will certainly look forward to reading it. Just a couple of things. So my own work at the moment is trying to understand James Wilson, the signer of the Constitution and of the Declaration, and his relationship to his Scottish roots and to his very wide-ranging reading in continental legal thought. So I'm kind of buried in this general set of problems. So just a couple of observations. One, I think Jim Whitman's absolutely right. The Hannah Arendt kind of contrast between, the good American Revolution, bad American Revolution, that does not stand up well to scrutiny. In fact, I have her book right here, check the index. She has 3 references to slavery, 2 references to civil war, 0 references to race. If you're talking about the American constitutional tradition and you leave those things out and then you say, what a wonderful tradition, how awful the French are, you've got a problem. Now, obviously, she was writing in the 1950s. It was the Cold War. There were reasons for emphasizing this kind of theme, which goes way back. But that's a problem with her account. There's also a more general problem with the way in which American history was written for a very, very long time, until actually, I would say within the past 10 or 15 years, in which the American Revolution was portrayed as essentially bloodless. So it was a Lockean revolution. It was all about ideas, and the bad British were thrown out, and there was no real violence. R.R. Palmer years ago pointed out that actually statistically there were many more refugees from the American Revolution than from the French Revolution. But even more striking, if you look at the latest historiography, it's just clear this was a bloody, violent, fierce civil war. And the population was deeply divided between loyalists and revolutionaries. And boy, either side, if they got the upper hand, they would go out and they would lynch their neighbors. It's kind of quite gruesome. Historiographically, of course, once the revolution was over, that entire past got papered over. And frankly, I was not aware of the scope of it until I started working on this Wilson stuff, because Wilson himself was nearly lynched a couple of times. So I began paying attention to what scholars were writing about it. But so, okay, general point, reconsideration of the two revolutions, not drawing sharp contrast between them. I think that's the way that the historiography now points. Second point is to express strong agreement with Mark's point about not overplaying philosophy, which I have something of a tendency to do since I'm a philosopher. But if you're talking about these traditions, I think he's absolutely right. You've got to look at the way in which institutions are interacting with the ideas, the way in which institutions can place constraints on philosophical thought, the way in which they can drive philosophical thought. So, okay, so basically what I'm saying is I agree with Jim, I agree with Mark, I think it's a wonderful book, and I'm looking forward to reading it.
Thank you. Yes, on your point about slavery, many intellectuals during the founding era were pointing out that those natural rights that they had in mind were in contradiction with slavery. But then again, it took the American constitutional system again about 100 years, right, to eliminate slavery, and another 100 to enact this civil rights legislation. But in France, the situation was more or less the same in relation to the colonies. And we are discussing tomorrow in another panel Professor Colley's book, in which he describes that the French Revolution itself led to a revolutionary movement towards the colonies. So Saint-Domingue, for instance. The force of the French Revolution and of its ideas were so compelling, inevitably it led many of the colonies to independence, right? So yeah, definitely these ideas of equality and liberty did not concern everyone within civil society, a limited group, but it's interesting to see that this limited group was the same in both those systems, right? So this is what we have, this is what we will compare. Right.
Not seeing a hand, let me jump in again at the level and make two observations. One, dwarf tossing is illegal in numerous states. That's what, in other words, at the state level, even to this day, there is no shortage of willingness to ban things that are considered immoral and that sort. It was banned in Florida as of 1989. Apparently this year, there's a Florida legislator who's thinking of reintroducing the practice. But at the state level, dwarf tossing is banned in lots of places. And what that points to is that, yes, certainly liberalism and distrust of the state and so on is a political theoretical thread that's available going back to the American Revolution, is there to be drawn on. But so are lots of other things. One can equally well, as Pocock does, for example, describe the American Revolution purely as an expression of Republican ideologies. I think he overstates that position, right? But you can. And so, to my mind, the question is why, when a libertarian view of free speech becomes popular, right? Why at that time, the post-World War II era, is there a drawing on this liberal political theory? Right, it was available, but it was one of many choices. It was selected and built upon. A mythologized historiography of the American Revolution was built around it, part of which indeed, included insisting that it was bloodless and peaceful and charming. So, this isn't a point of disagreement so much as a point of suggesting there's more contingency, more institutional engagement, more interests involved, more deliberate choices than appears if one adopts a sort of Louis Hartzian view that the American Revolution was fought on Lockean principles. The John Quincy Adams, right? There's a moral obligation on the part of the government to improve people. That's part of the American ideology as well. It's not the one that gives you a libertarian free speech doctrine, but it's definitely there to be. Anyway, so that point is, I think, obvious, what I'm trying to say. Do others want to jump in? Oh, please, sorry.
Yes, so I think that everybody was reading all those thinkers. It's just that they were reading them differently. So of course, Locke was also relevant in France. Rousseau was relevant in the US, but they were drawing different implications of their thoughts. So Rousseau was reading the US, and he was interesting. And it's, I think Adams cites him. But the point that he's trying to make, reading Rousseau, is that society is natural. And if society is natural, he doesn't draw the implication that it needs also a strong government which will regenerate the citizens, because the political needs were different at the time. They didn't need the government to go that far.
No, but Adams does. Wait, I'm sorry, that's not correct. Adams does draw. He says sumptuary laws are laws regulating how people dress and whether they can have parties and where they celebrate things. And Adams thought these were essential. He thought it was absolutely essential to people.
Yes, but at the same time, he was criticizing the democracies as they existed in antiquity because he thought that they didn't have enough checks and balances in order to protect negative liberty, right? So maybe there were some minor contradictions, but so this tradition of libertarianism became more meaningful later. But something else also. Republicanism was extremely relevant to the US and to France, but I think there were nuances in the understanding of republicanism. So in the US, the understanding of republicanism, as Pocock has also noted, discussing the Machiavellian moment, right, this extremely important book. So Machiavelli was extremely interesting and relevant for the Americans because Machiavelli already had this idea of checks and balances in some form. He was discussing how different social groups within a society balance out one another, right? So already the idea of limited government and the idea of a scope for negative liberty exists in Machiavelli, and this is why his version of republicanism was meaningful in America, and this is what Pocock also emphasizes. He didn't impose high standards of virtue like the ones that ancient Greece had, for instance, that were acceptable in antiquity. I think in France, there was a tendency to see the state as having also a moralizing role. So there is great proximity to the ideas that were dominant in antiquity, and that it's the mission of the legislator to make sure that the citizens are virtuous and good. In different political circumstances, and of course the relevance of Rousseau there, but he was not obviously the only thinker that defined the French tradition either. But some elements in his thought, the fact that human beings, when they think about what is right or wrong for themselves, they should consider everybody else, they should take everyone in consideration. When I engage in a dialogue about what is right or wrong with myself, I must ideally include everyone in my community. So those ideas were relevant there. And this idea also that Rousseau articulates that human beings are naturally good, they have the sentiment of pity, they have very deeply in themselves, and it's a mission of the state to help them bring it back to surface. This was extremely relevant because this is what exactly the French were trying to do, reform and regenerate their civil society. They were faced with a hierarchical society, which they considered was profoundly corrupt. Tried to moralize it, they failed. They derailed into the terror. Democracy was not operational for them. So, but what is the point there? Ancient ideas about the mission of the state being to moralize the citizens were very popular in France during the French Revolution because I think it faced those specific political needs. They were not all that relevant in the US because the US had already this experience with how the law can operate. The law might operate liberty excessively. There may be some other higher standards in reference to which we should be measuring the validity of the law. So relatively speaking, again, I think that republicanism in the US took this idea of natural rights into consideration. French republicanism thinks that we should forget about our natural rights. We have rights because society is natural and gives us those rights. And we have rights because we also have duties. We contribute to society, and in return, society gives us rights. And it's the mission of the state to help us realize our liberty. And this reference to the general will, again, as this fiction that must as this idea that must permeate the state and must define all government policies. So it's a very fine difference, I think, but there is a subtle difference, nevertheless, in the understanding of Republicans, which existed already during the founding era, and whose implications political actors were able to draw much later.
I'm afraid we'll have to leave it there as we're out of time. I want to thank Ioanna, of course, and Mark and Tim and Rick for providing a very stimulating discussion. Let's give everyone a round of applause if we could.
Thank you very much, all. I was delighted. This was a super stimulating conversation, and I think I have terrific ideas for my follow-up project now.
Very good. I think that's the best outcome that can be hoped for.
Absolutely, absolutely.
Bye-bye.
Wonderful.
Bye-bye.
Congratulations, Ioanna.
Thank
Congratulations.
you. Thank you.
And what a lot of